curfew order was lawful. And the government had a rational basis. They had a good reason to go ahead with this. And it's not for the courts to second guess in the times of war. Okay. Questions? On the Korematsu, I'm sorry, the Hirabayashi majority opinion. Anything on the majority opinion? Now, there are several separate writings, and the reason why I think the concurring opinions are important is they reflect that not everyone agreed with the majority's approach. Even at the, right, it's easy enough for us to sit here 70 years later and say, oh my God, this was insane, right? But at the time it was decided, people on the court were able to articulate why this was wrong. Justice Murphy, who we know would later dissent in Korematsu about a year later, said, look, I don't agree with the majority all the way. We're not supposed to give the military blind deference, but this is a narrow case. We'll just focus on the curfew. Right? We have to give the military some deference, but they don't get all deference. All right. So you have Justice Murphy, who was like a little bit uncertain, and you have Justice Douglas, who's like, well, the problem here is loyalty, not assimilation. So he's not signing on to all the racist stuff. He's sort of distancing himself from that a little bit. But only question is, are they loyal? And the curfew doesn't concern whether people are actually being locked up. Now, the justices knew in 1943 that they had these internment camps. And again, these orders were put up in 42, 6 months after Pearl Harbor. So the justices knew what was going on. They had newspapers. But they decided and set this very narrow issue only on the curfew. They didn't take up the exclusionary case yet. All right, so any questions on Hirabayashi?
Yes, sir.
Yes, sir, go ahead, Tyler.
Justice Douglas, what he says about he says we cannot override the military judgment. That's not exactly true, is it? I mean, if they wanted to, non-delegation, they could.
Look at Endo. Look at Endo a year later. They did.
But wasn't Endo, like, their argument was it's not a military, it was a civilian agency that was detaining her?
In Endo, they reached a very narrow technical ruling. But the upshot is they were telling the military, you can't run this camp. I'll jump at the Endo a bit, but I think if you polled every member of Congress, they said, oh yeah, we wanted them to build these camps, right? Congress was appropriating money for these camps, right? These camps aren't being built out of magic. Congress was aware of them. There were commercials, films being put nationwide on the newsreels. I showed you that movie before. This wasn't a mystery, right? Endo was such a strange opinion because well, we don't think Congress would have wanted this. When, yeah, they did. They gave Roosevelt a blank check, and they kept writing more checks, and they were okay with it. So to Tyler's first, I think your questions are well put. The court ruled in Endo in a very narrow way, but effectively, they were telling Congress you can't do what you actually wanted to do, which was to mount these camps. But we'll get to Endo in a few minutes. Okay, Tyler, I'm sorry, Tyler, you want to give me the facts, please, in Korematsu? Very, very famous case, which most people know the name of just by name. There's Fred Korematsu right there.
Yes, sir. So this is the additional layer following the curfew that had been upheld. This is where they're talking about the exclusion component. And you mentioned earlier, I don't know if he says rigid scrutiny, strict scrutiny.
That's it.
That's the kind of the initial introduction of such. So this gentleman is an American citizen, like you mentioned. Civilian exclusion order about reporting to the certain assembly areas or camps. And the Justice Black, in writing the opinion, said although all legal restrictions restrict the civil rights of a particular group, it doesn't mean that in this case that's necessarily unconstitutional. So this layered on top of the previous case.
Yes.
Hirabayashi. Justification of, at times of war, exceeding certain constitutional limits are essentially okay and definite and close in their relationship, to preserve the armed forces and protect against sabotage and espionage.
Very good. Thank you, Tyler. So again, Hirabayashi was 1943. Korematsu was the following year, 1944. Both cases were premised in the same executive order, and both cases were premised on the same statutory authority, that is, laws of Congress. Once you uphold the law at issue in Hirabayashi, right, once you uphold the power to enforce the curfew, then Korematsu is an easy case, right? If the military has the power to execute the curfew, then they have the same power to execute the exclusionary order. They rest on the same law. As a result, you have res judicata, right? You can't come back and now argue that there's a non-delegation problem because the court order resolved that question in Hirabayashi, right? It's within the same authority. All right? And once again, like in Hirabayashi, the court defers to the government. If the government deems something necessary, think of like the necessary proper clause, the courts will not second guess whether in fact that is necessary. And this again raises the question of deference, right? How much should courts scrutinize or second guess whether in fact something in fact is necessary? Remember, Thomas Jefferson thought that the bank was not really necessary to regulate commerce, and the court said yes it is. Was the regulation of local wheat necessary to control prices nationwide? Probably not, but the courts aren't going to second guess them. When you have this sort of deferential doctrine of necessity and you defer to that, then Korematsu becomes a much easier case to decide. Now, Fabian, let me ask you this question. What alternate options could the government have employed if they were, let's just pretend there actually was sabotage, right? So let's just pretend for a minute, right? What else could the government have done to root out sabotage and spies, short of rounding up thousands of people in camps? What else could they have done?
Why was there not some kind of interview process?
Oh, I like that. Yeah, give me a little bit more. What do you mean?
Interview process, like what? Okay, let's say they have jobs. Like, why couldn't you go to their jobs or pull records? Or
Yeah.
I'm sure it wasn't to the extent, now the computers and all that, but I just feel like there are probably less costly ways to do this, and then less.
So basically, give a loyalty oath, maybe. Right, run a background check, maybe. Yeah. Okay, so I think Fabian makes a fair point, right? If they were actually concerned about people engaging in espionage, the government could have probably done something else to determine if there actually were spies among them. Yes, Roche?
I think it was on this case or the case before it where they actually said that they had a list of 5,000 individuals who were not willing to take the loyalty oath. So that right there you have.
Maybe lock those people up.
Yeah.
But everyone else you can let go.
Yeah.
Now, Soros, let me ask you a question, right? Look at this poster they put up. May 23rd, and we got to round you up by tomorrow. How much time do you think it would have taken to run background checks on tens of thousands of people?
Months, probably.
And there were no computers there.
So probably a year at least.
Maybe years. And then what do you do while these checks are ongoing and these people are still by the coast?
I mean, what they could have done is, register them. They could have sent,
There's no tracking. There's no GPS. You can't put an ankle collar. They didn't have GPS. Faven?
But my question is, okay, like, sure, like this was posted and they were given like less than 24 hours or whatever, but this conflict didn't start like that day. It's
I know. I promise I'll get there. I'll get there in 2 minutes. I'm just doing the devil's advocate first, right? I promise I'll get there. But Sarosha, let me just finish up this line of thought. Let's presume the government needed these people outside the coast within 24 hours. Let's say they were worried that this is going to happen on May 25th and they got to get these people out. Would a loyalty oath have worked? Just presume for a minute.
I mean, we can assume that people will not everybody is telling the truth when they are taking the
Yeah.
loyalty.
So maybe as an emergency measure, the only thing you can do is exclude them and figure out the details later.
Yeah,
Oh, I know. It's insane, right? I'm not telling you that's right, but think of it from the court's perspective, right? The government comes and says, we have to get rid of these people immediately, and we don't have time to do this other crap. We can't run all these background checks. We don't have time.
I kind of like Justice Jackson's dissent. Just like thinking of that, like I'm like, okay, yes, I understand that you have Japanese Americans that you have to exclude, but you're not doing the same thing to Italian Americans.
Oh yeah, I promise we'll get there. We'll get there in a few minutes. We'll get there. But I want to come back now to Favin's point from a moment ago. So again, Favin, these cases are 1944, right? Nearly 2 years have now passed since these posters went up on the wall. Has the government started to do background checks and administer loyalty oaths and maybe send some of these people home? No. So then what does that tell us about their concern about separating the loyal from the disloyal?
It wasn't as much of a priority.
No. Maybe it wasn't a priority at all. And Faven, I'll just ask you the follow-up question, if I may. If their concern wasn't really about loyalty, what was actually motivating their actions?
I mean, I guess what's said here is to protect the U.S.
But again, if they're not actually checking who's loyal, who's naughty, who's nice, right? They're not actually checking about loyalty, then what may have actually, in fact, been motivating their behavior?
I thought it was racist, but...
That's what Justice Murphy says, right? Justice Murphy says it's the ugly abyss of racism. He says it quite bluntly. But what I'm doing here is what we call the sort of means and scrutiny, right? What is the government doing? What are they trying to achieve? They say we're excluding these Japanese Americans as a means to separate who's loyal and who's not, right? We need to figure out who's who. We need to figure out what's going on. But if they're not actually doing what they say they're doing, they're not actually separating the good from the bad, then that calls into question whether this sort of policy is in fact necessary, right? Or is it achieving some other goal? But that's the magic of deference. If the court starts from the
go down to deference, right?
Yeah.
Okay, so since we're taking it from that perspective in terms of deference, right? Okay, I understand that, but even within that, right? So what are the boundaries within that? Because if we're saying, okay, it's not racist, whatever, well, what about the protection of these people, right? To a certain extent, like to put someone in internment camps.
Right, without any trial, nothing.
Without any trial, and then like we'll pass it off as like, oh, it's better.
Well, okay, that's a separate question of the due process. I'll get there in a couple minutes, I promise. Right, that's Fifth Amendment's up. But I want to first just talk about the actual policy justification. Right, we'll get to the Fifth Amendment. I promise. We'll get to the Italian. That, they didn't do the other people. We'll get there. I promise. But here, I want to focus on one point. If in fact their goal was to separate the loyal from the disloyal, they've done nothing in the 2 years since to actually do that, which suggests that the reason why they're excluding people is not to help them figure out who's loyal and disloyal, but it might be some other motivation which falls to the abyss of racism. Yeah.
Well, I feel like they almost have passed a judgment by saying that Japanese Americans, regardless of, we're not going to even go into who amongst them is loyal or disloyal. We're just assuming that they're disloyal.
Yeah. It's an assumption without any trial, right? Now, I'll do the due process angle for a minute. The Fifth Amendment says a person cannot be deprived of life, liberty, or property without due process of law. Generally, these people were being deprived of their liberty. They're being held in or actually, to be precise, excluded in this case. And they were afforded no process whatsoever. For 2 years now, they could have been having some sort of procedure, but they've had none. The court, I think, recognizes this, and they even say that when you have these classifications on the basis of race, they have to be, carefully reviewed, right? But let me get the exact quote where they say this. The court says that all legal restrictions which curtail civil rights of a single racial group are immediately suspect. What do they mean suspect? Think of like suspicious, right? We're suspicious of these laws. This gave rise to what later became known as strict scrutiny, right? That when you have a racial classification, the courts will strictly scrutinize it. But the court says that's not enough, though, right? You subject them to the rigid scrutiny or strict scrutiny, but pressing public necessity may sometimes justify the existence of such restrictions. Racial antagonism never can. So here the court again rests on the fact that there is in fact a necessity, public necessity for this rule. As a result, the power to exclude includes the power to exclude by force if necessary.
So they mentioned that it has to be strict scrutiny or rigid scrutiny. So are they saying that public necessity overplays that, or?
They're saying that generally you can only exclude based on race if you have a really good reason. And here, the government has a really important reason. Right? The court writes that Korematsu was not excluded because of hostility to his race. He was excluded because we're at war with Japan, and the military authorities feared invasion of the West Coast, and they were constrained to take proper security measures. And the very last sentence, they say, we cannot, avail ourselves of the calm perspective of hindsight. What does that mean? 2 years had now elapsed, and these people are still sitting in these camps, and nothing happened. Right? There was no sabotage. I think there were some small instances of sabotage, but it was pretty trivial stuff. Right? It wasn't anything of this scale.
Say no collusion, no obstruction.
Oh, you're funny.
Is the point like what they were saying is, and rather than having these people in 2 years, we're trying to like protect them to an extent, right? By doing it within 1 day, so at least they didn't, we didn't waste all this time for that. Is that like the angle?
I think it's close. I think it's more saying we have to assess this based on what was known in May of 1942, not what we know in 1944. Right? We can't let hindsight cloud our judgment. That we have to assess this based on the face of the order and the prosecution as the time it began, not based on what we know happened 2 years later. Does that make a little sense?
So you're saying, okay, so
This order was from 1942. The case got to the court 2 years later in 44. And then what the court's saying is we can't let hindsight cloud our judgment. Right? Everything's calm now. The war was winding down in 44. But in 42, Pearl Harbor had just happened, and there was a lot of uncertainty. And was the government justified at that time? Right? Pearl Harbor was December of 41. This happened 6 months later. Are they really going to say 6 months after Pearl Harbor the government acted unreasonably? And we can't let what we know now affect the judgment at the time of 1942. Make sense?
No, I understand what you're saying. I'm just saying, like, so, I'm not talking about in light of that time, so in 1942, in May, when this happened, it just seems like pretty hazy to say that, like, we go from the means ends test to deference, and then it seems like a very hazy way to justify all of it. Deference, it seems like we're really like using the extent of it.
Well, I mean, think of, again, we've done deference before. Think of McCulloch, right? Think of legal tender cases. Think of, we did the cases during the New Deal. If the government wants to ban local marijuana to regulate interstate marijuana, we're going to defer to it. That's what Justice Stevens said. So we've had a lot of instances where there's judicial deference. This case is a whole different ball of wax. It involves people getting locked up. But the framework for deference was laid long before Korematsu, right? It's the reason why they cite McCulloch in this case, or I think actually the other one. But they cite McCulloch for that reason, right? The courts are not supposed to get in the way, and that's what Marshall more or less held in McCulloch. Right, when the government decides that there's a necessary thing they have to do, the court should be hesitant to second guess whether in fact that is necessary. Again, with the Bank of the United States, that's boring, right? Who gives a damn, right? But with this, the exclusion executive order, that's it's a different story altogether. Right? Make it a little more sense? Okay. Lindsay, you okay?
Yeah,
You look a little stressed.
I don't really know that I want to ask my question right now, but in light of all this,
Yeah.
how are we detaining people now the way we are?
Where? Which?
Like the illegal immigrants and things like that. I mean, I've seen articles where there was a Hispanic man up in, I want to say, Wisconsin, who was actually a Marine, and ICE detained him. He was a U.S. citizen with a Hispanic last name, and he was detained in one of these camps. It's just really hard for me to understand how this is almost, to me, it almost seems like this is happening again, although I understand they're not citizens, at least some of them aren't, but we do have some Hispanic citizens who have been detained in these ICE camps. So I just don't see how, it's just, it's frustrating and it's angry.
All right, so I'll try to answer your question as best as I can. As a general matter, immigration is a sort of an in-between rule. It's not considered criminal. For example, if you're in this country without authorization, that's not actually a crime. The phrase illegal alien is something of a misnomer. Generally, the crime is entering illegally or overstaying a visa, for example. That could potentially be a crime if there's fraud involved. But most people who are simply not present lawfully, the lack of what's called lawful presence, are not breaking the law. Immigration is considered quasi-civil, right? So in order to detain someone in these sorts of proceedings, they're given some process, but not the same amount of process as you would for a criminal prosecution. So generally, a person can be detained with more or less the affidavit of an executive branch official, although that's only for a short period of time. People who claim asylum and otherwise are allowed to speak in front of immigration judges. Now, immigration judges are members of the executive branch. They're basically appointed by the Attorney General. So it's not the same sort of Article III judge otherwise. That's a short answer to your question. But I think the mere fact that people are being detained for immigration violations is different than people being rounded up simply because of their nationality.
But you can see the parallels.
Oh, the visual
you have
parallels.
Children that have been separated from parents and all sorts of stuff.
Yeah,
I mean,
visually it seems on point. In fact, some of the migrant children are actually being held, I saw this headline yesterday, at a facility in Oklahoma. Let's see if I can find it on the map.
one of these facilities?
Yeah, I think it's one of these. Where's Oklahoma? Yeah, there it is, Fort Gill. Yeah. Yeah, where that star right is?
Fort Sill?
Yeah, Fort Sill, I'm sorry. That they're actually, some of the people who were overflowing from Texas are actually storing them there, which was one of the facilities used in the Korematsu. So I saw this yesterday. I mentioned it, but I think not now you brought up I would.
Yeah,
Yeah.
I'm just struggling with it internally.
It's okay. You're allowed to struggle. It's healthy. Okay, any other questions on the Korematsu majority? I think we've talked to the majority a little bit, but we'll do the dissents in a bit. Anything on the majority? Who's next? I think you're next.
No,
Oh, you're Soresh. Okay, you're next. I'm sorry. All right, Soresh, let's walk through the. Yeah, let's do the separate opinions. So bring me to Justice Frankfurter, concurring opinion. Again, he was on board, but with a little bit of hesitation.
So reading Justice Frankfurter, I almost felt that he was kind of going along with it because of the, I don't want to butcher that name.
Hirabayashi?
Hirabayashi.
He felt bound by that precedent?
Yeah. Like, I felt that he wasn't necessarily buying the government's argument, but he was more bound by the previous precedent's case.
Yeah.
I'm just reading that, but.
Yeah, but I mean, so that raises the question, Suresh. Let me ask you this follow-up. When Hirabayashi was decided, Frankfurter knew what was going on, right? There were newsreels on TV. Wouldn't he have known that his opinion, Hirabayashi, would necessarily lead to a follow-up decision concerning exclusion?
I'm sure he did, but at the same time, I think in Hirabayashi, he was more concerned about the loyalty than he was about
Yeah.
the ramifications of his decision.
Yeah, I think that's right. I think that's correct. Frankfurter is definitely a little apprehensive, but then he says something. He says, "This is their business, not ours." Right? Basically, it's like, okay, I don't like this at all, but it's not for the courts to intervene. Yeah. So I think Jackson. I'm sorry, I'll get to Jackson in a minute. But I think Frankfurter is very. And I mean, you already read Youngstown, right? And keep in mind, Justice Black was the majority here in Korematsu. Then he wrote the majority in Youngstown about 8 or 9 years later, right? Frankfurter was in the majority in Korematsu, and he wrote the other opinion in Youngstown. So I think a lot of the frustration from Korematsu spilled over to Youngstown. It's like, okay, now we're really going to tell the executive he can't do it, right? Yeah, Fabian. Please.
So, since like with all the cases that we're going to read, right, they're going to have tough issues. But the only thing we're looking at is whether, the Constitution applies or if it doesn't. So, like, depending on whatever's being upheld or what's not based on the Constitution, once we get past that, just like for myself, so if I'm thinking through like the human rights issues and that kind of thing, that's a separate thing. So how would someone go about answering that? Do they have to go through like Congress and such? Like, let's say if the Constitution upholds it strictly, right? Like in these scenarios. So, it's okay with the Constitution, but if someone wants to make another argument, like how are we going to protect those people?
Yeah, sure.
How does that work?
I mean, there's a reason why Fred Korematsu ran to the courts, because Congress was in favor of it, right? And the president was in favor of it. And it took decades, I think, for American people to recognize that this was a screw-up. And that's decades of advocacy and organizing and raising awareness. It's not a quick process, right? It's not as simple as marching on Washington. It sometimes, and it's not a good answer, but change takes a really long time, and it doesn't happen overnight. We'll do the gay marriage cases later this term, but basically in 1986 or 7, just I'm off maybe by a year or two, but it's in 86 or so, the court ruled that the states can criminalize sodomy. And then barely 3 decades later, a majority of states had approved of gay marriage in their own jurisdictions. And that didn't happen overnight. And there was a lot of persuasion that went into that, a lot of social change. And you can write books about this process. But you couldn't just go to the Supreme Court and say, we want this. So, if you want to change the world, don't go to the courts.
No, that
Yeah,
helps because
yeah.
you know how I'm always going to look at it from that angle.
That's fine,
But so
yeah.
I don't keep asking these questions.
You can
in
ask me.
middle class.
We have 5 people. You ask me whatever you want. This is a free pass to ask me because you got like no one here.
But I want to make sure that I'm understanding, the constitutional approach to stuff, and I'm not just always like, okay, this is the ruling, but anyway, like, what about these people too? Like,
I mean, look. I mean, what happened to Korematsu? Bill Clinton, the president, gave him the Medal of Freedom. What, 40, 50 years later?
yeah.
That's kind of cool.
Yeah.
But it took him 50 years.
True.
Yeah, so eventually, and in fact, he got a reparations check. And there was another incident where a federal judge, I think in Washington, issued what's called a writ of quorum nobis, which is basically where they nullified his conviction. Because think about it, it was with Korematsu v. U.S., he was convicted of a crime. He was a convicted felon, right? He would have been disenfranchised from various civil rights, right? He probably couldn't vote. He couldn't bear arms. He couldn't do other things, right? So actually in the 1980s, a federal judge actually vacated, nullified his conviction. It took him, 40-something years later. Yeah.
So that's the court of history thing.
Yeah, I mean, well, that vacated his conviction. I'm not sure if that goes to the Roberts' Court of History thing. I was kind of annoyed at Roberts. I thought it was a. I know he meant well, but no one took it seriously. Right? It was big. It's like we're upholding this travel ban, but we're going to say something good about Korematsu. Or actually, bad about Korematsu, but say something good concerning the issue.
I kind of find that oxymoronic.
Oxymoronic. Tell me why.
Well, at one point he's upholding what you could say is the executive overreach, while condemning the executive overreach.
Yeah.
The same executive overreach.
Yeah. I didn't assign the travel ban case. I assigned it last semester. I didn't assign it this semester, and the reason why is because the majority opinion is based entirely on statutory interpretation. Roberts doesn't decide any constitutional questions. It's all about, does a statute give the president this power? He didn't need to reach the constitutional question because he resolved it narrowly. The dissent by Justice Sotomayor is very good on the Establishment Clause, but I'm not going to be teaching you that because you have to take a First Amendment class, and that's required. So I didn't assign the travel ban case. If you want to read it, I'd be happy to talk about it. It was an important decision, but I don't think it has a place anymore without the First Amendment stuff in this class. That's why I didn't assign it. But you're welcome to read it. Yeah, I did a lot of work on that case. By the way, Roberts used almost all of my arguments. He gave me no credit, but he used all my arguments. It's fine. All right. Let's do Roberts. Lindsay, I think you're next. Justice Roberts. Again, this is the same Owen Roberts, the so-called switch in time that saved 9, right? This was the progressive appointment by President Hoover. I think he was the only Republican left in the court by 1944, if memory serves. I think I'm right on that one. But what did Justice Roberts say?
Justice Roberts said that it was not clear that Congress had given President that much power, and it was a violation of the Fifth Amendment due process clause.
Yeah, and I think this is an obvious point, right? That these people were given no process. And moreover, Korematsu was basically being held there for years without deciding whether he was unloyal. Now, he had a trial of whether he violated the statute, but he admitted he violated it, right? Hirabayashi said, yeah, I violated the curfew, no question. Korematsu, yeah, I violated the exclusion order. So because the facts were clear, the court said, yep, you're guilty, right? But the question is, was the charge, was the law that he was tried under, was that law itself valid? Okay? And let's do the last one, Justice Frank Murphy. Justice Murphy was at the time there was one Jewish seat, which was Frankfurter, and there was one Catholic seat, which was Murphy. There was always one Catholic and one Jew. Before that, it was Justice Brandeis, and also it was Justice Pierce Butler, who was a Catholic. Murphy was the lone Catholic on the court, so maybe had a different perspective than the others. So Chelsea, walk me through the Murphy opinion, please.
So he said that this goes over constitutional powers, and he does refer to it as the ugly abyss of racism. But then he also says that there's no good evidence to actually justify that these people are a threat or disloyal to the United States.
Yeah. Now, Justice Murphy seems to suggest this violates equal protection of the law. But if you look at your Fifth Amendment in your pocket constitutions, I forgot to put it up there. The Fifth Amendment does not have an equal protection clause. It has a due process clause, but it doesn't have an equal protection clause. Murphy doesn't actually explain how the federal government, which is bound by the Fifth Amendment, violates the equal protection clause. 14th Amendment controls the states. The court would actually basically agree with Murphy about 10 years later in a school desegregation case called Bowling v. Sharp. But here Murphy doesn't really explain himself very clearly. But at a minimum, right, he says that this is falling into the ugly abyss of racism, and that this exclusion order is unconstitutional. He writes, there's a test whether the deprivation of rights is reasonably related to a public danger that is so immediate, imminent, and impending. Justice Murphy effectively says that there's no reason to do this. Whatever rationales the government giving us are not entitled to great weight, right? Why can't they hold hearings to separate loyal from the disloyal? Why aren't the Germans and the Italians being treated in the same fashion? Right? We're now 2 years later, and the situation is not as urgent as they represented. Not one Japanese American was accused of being engaged in Pearl Harbor. Right? You have 100,000 people who are subject to this. Then he writes at the end, I dissent, therefore, from this legalization of racism. Racial discrimination in any form and in any degree is no justifiable part whatever in our democratic way of life. It is unattractive in any setting, but is utterly revolting among a free people who've embraced the principles set forth in the Constitution. All residents of this nation are kin in some way by blood or culture to a foreign land. Yet they are primarily and necessarily a part of this new and distinctive civilization of the United States. They must accordingly be treated at all times as the heirs of the American experiment and as entitled to all the rights and freedoms guaranteed by the Constitution. Okay. Questions on Justice Murphy's dissent? 6-3 vote. So you had Roberts' dissent, you had Murphy dissent, and Jackson will do next. Any questions on Justice Murphy? Is Chelsea next, or is it Tyler? I can't remember. Tyler. You want to give me Justice Jackson, please?
Yeah, I had to look something up because I didn't really know what he was talking
Please.
about. He cited a part of the Constitution of which I was unfamiliar. Forbids its penalties to be visited upon him, provides no attainder of treason shall work corruption of blood.
Yeah, this is an obscure part of the Constitution.
Yeah.
It basically says that, let's say, you know, I am a criminal, right? Back in England, what would happen is if a father was a criminal, you basically have an attainder or a taint of the blood that my son, or it will be a son, but my son born into this world would also be tainted as a criminal. In other words, you would have a bloodline with a liability attached to it, that from generation to generation, heirs would then be subject to this criminal idea. And Justice Jackson writes that this is not our way, that we have a prohibition on these corruption of the blood, that these people cannot be held liable merely because their ancestors may have hailed from a foreign land. A lot of people were born in the United States.
I didn't. So again, he said something that sounded a little off. That basically that the judiciary didn't have the ability to evaluate a military order. You know, I still think under the basis of non-delegation, you know that could have been the standard by which they used, but you know within it. Ill-equipped or not ill-equipped, the military order's extent to the civilian population was a question that he raised, and kind of, you know, the loaded weapon comment
Yeah.
set, you know, us up for I think what was coming very shortly with the next one, Endo.
Yeah. Very good. Justice Jackson effectively says that how are we to know this is reasonable? There's no evidence. Right? We have no evidence except for the the general self-serving statements, which are not tested in court. Right? And he's not going to base his case on these untested statements. And then he has this very famous line, which he says, this principle of deference can lie about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. And this is why I think it was significant that President George W. Bush did not cite the Guantanamo cases for some good reason. Okay. And again, this is the same Justice Jackson who wrote the opinion in Youngstown concerning the zones of authority, and he was later the Nazi prosecutor, so he had a very strong opinion upon this case, even at the time. Okay. Questions on Jackson?
Did he ever come back to his Twilight zone of Twilight?
He died shortly thereafter. I think he died in 1953 or 4. And Youngstown was what, 48 or 49? I can't remember the year. Youngstown.
Youngstown was after this.
Yeah, I know. What year was Youngstown? 48? I'm sorry. Duh. Youngstown was 52, and I think Jackson died maybe a year or two later. He died shortly thereafter. He had a heart attack. He actually died in his secretary's apartment, who was probably I think it was his mistress. Back then, when men had heart attacks in their mistress's house, they found a way of covering it up. But I'm like 90% sure that's right. But he basically, either he died in her apartment or he died with her nearby. But it was his secretary. Yeah. 54 he died. Thank you so much. So he died 2 years after Youngstown. Yeah. Okay. So any other questions on the majority or the concurrences or the dissents in Korematsu? Now, let's just peek ahead a little bit and look at the timing. Korematsu was decided the same day as Endo in December 18th of 1944. There's some evidence to suggest that Roosevelt knew about this date and that the court basically held on to the opinion until Roosevelt decided to shut down the camps. And the government published and announced that they were going to wind down the camps. By the time Endo was decided, the next case, by the time Endo was decided, the issue was moot. The camps were already scheduled to be shut down. Now, that doesn't vacate Endo's conviction, right? So her conviction still could have been reversed. But the legal effect of these cases was pretty slim. And by January of 45, the orders were rescinded entirely. The interns were given a $25 and a train ticket back home. But this was the case we had. Oh, by the way, I was wrong. The reparations are $20,000. So each survivor got a $20,000 check. And the government later admitted to the courts that they gave false information to the Supreme Court. All right. Questions about Korematsu? We'll do Endo in a minute. But anything on Korematsu? Okay. Endo is, I think, one of the weirdest cases that I have to teach back to back. Because we just did Hirabayashi and Korematsu. It was all about deference. And we had to, Endo's like, where the hell did this come from, right? Was this the same court that decided this case? I think Tyler, you're next, or Fabian? Who's next? Okay, Fabian. You want to give me the facts, please, in Endo with this case?
So, let's see, I don't know.
That sounds good to me.
Endo, so she was an American citizen,
Yes, she was.
American, living in Sacramento, California, and then she was sent to the relocation center, also in California, but in a different county in California.
Good.
And pretty much her argument was like, why am I being detained, or why am I being relocated if I'm?
Yeah, the key word is detained in the camp. Yeah, so you're right. Yeah.
Why am I being detained in a camp if I'm a loyal citizen?
Good.
And then pretty much, I guess, like her argument, or the court's argument moving forward is that she's not being detained by the military. She's being detained by the War Authority Relocation Center or something.
Good.
And since it's not the military, that they don't have the right to do that. And
Okay.
that they should release her.
All right. Now, Fabian, so here's the $1 million question. Why does she win her case? What's the argument of why Endo wins her case, but the other two, Hirabayashi and Korematsu, lost? Why does Endo win? What's the argument?
It seems like it's the really niche thing that is based on like where it is versus where it's not. Like because it's not owned by the military, or it's a separate entity.
What do you mean?
Well, maybe separate entity, not the right word, but maybe because it's not like something under it.
Well, let's start right here, right? We're dealing with the same statute and executive order that was at issue in other cases, right? The same statute, same executive order. Why does the court think this case comes out differently than Hirabayashi and Korematsu?
Because she didn't violate anything?
No, she willingly violated. She did not go to the camp. She did. George?
It's because Order 1966 and Order 9102 are delegating the authority to the military, not the civilian.
What did Congress intend when it enacted the relevant statute?
To, using modern terms, detain enemy combatant potentially.
And did Congress intend to allow these detention camps to be created?
No. I mean, they did, but according to the Supreme Court, they didn't.
Fabian, you want to add something?
Yeah, I was just gonna say, because they weren't unlawful, that Endo wasn't, so she wasn't being held against espionage or against sabotage.
Okay,
so.
good. So think about it this way, right? The court's basically saying, we don't think that Congress actually intended to give the president the power to create these detention camps. Okay? Now, if that was Congress's intent, that would violate the non-delegation doctrine. That's a bridge too far, right? Congress can allow curfews, Congress can allow exclusion, but Congress cannot allow detention camps. That's too far. So we will read the statute to avoid the constitutional conflict. And how will we read the statute? We'll say that simply Congress didn't give the president this much authority, therefore the detention policy is unlawful. It's like Obamacare, right? It's to avoid rendering the entire statute unconstitutional, we will limit it, we will narrow it in this one context to deny the government this one power, right? That all of Obamacare is fine, but they can't mandate that the states expand Medicaid, for example, right? We'll just pretend Congress didn't intend this. We'll save the statute. It's a saving construction, right? The court's saying, like, we have this duty to uphold laws. We have this obligation to find ways to read statutes to be constitutional. And here, we will read it to say that Congress didn't give the president this power, therefore the detention policy is beyond the scope of the congressional authority. This is like one of those unsatisfying opinions, I think, in the entire book. It's got to be up there, right? Because we just had two opinions basically saying the non-delegation doctrine is dead. You had Hibayashi and Korematsu. But here they're saying curfew, whatever, exclusion, whatever, but you can't do detention. But if you can exclude, you got to put them somewhere, right? The power to exclude, I think, has to include the power to detain, right? You can't exclude without detaining. Conversely, you can't detain without excluding. They're bound up together. You exclude someone, you got to detain them, and if you detain them, you've had to exclude them, right? These powers are, I think, bundled together. But the court draws a line and say you cannot go too far. And again, Congress had appropriated money for these camps. Every member of Congress knew this. But the court finds this really narrow, textual way of rendering the policy unlawful. And that's it. Therefore, Endo has to be released. Again, it's such a strange opinion after doing the first two. Every year, I was like, wow, where did this come from?
So were there any studies about this, so that the War Relocation Authority had a process by which people could apply for indefinite leave? Do we know, is there any data that was actually successful?
I don't know. I have no idea.
I mean, I found it interesting is they had this process. Allegedly it was available, but Endo didn't follow it. She didn't file her application.
This might be one of those processes that exist on paper only,
right,
and it's not actually granted.
True.
Yeah. I don't know the answer. We have Murphy concurring, right? Saying this is still racism, right? This is still racism, you guys. Nothing changed. Justice Roberts writes another concurring opinion saying, "Look, I can't join this bullshit, basically, right? It's like this is Korematsu decided the same day. You can't keep avoiding these constitutional questions. Everyone knows what's going on. And the court is unjustified in straining to conclude that Congress did not mean to ratify what was done. Right? Everyone knew what was going on. The idea that Congress didn't intend this is facetious. There we go. So any questions on Endo, Korematsu, or Hirabayashi?
This is why I said, when I said earlier that this is one of those things where it's like racist with constitutional stance.
Yeah, I mean, I think the policies at issue in Korematsu violate due process, forgetting the non-delegation stuff. People cannot be interned without any sort of procedure. We talked about habeas corpus in the ex parte Merriman case. These people were locked up for years without any sort of procedure at all. So I think as a procedural matter, these orders were unlawful. I think as a non-delegation doctrine, it's even easier. Congress didn't enact the statute they needed to enact. They would need to enact much more precise guidance. But then again, I'm a fan of the non-delegation doctrine. I raise it whenever I can, but the court killed it after 37.
So that's no longer a thing.
Not really. Only in my mind, in my fantasies.
So how is extrapolating to modern time, how is the federal government getting away with Guantanamo Bay and the changes there?
Okay, yeah. So I don't assign the Guantanamo cases because I think it's too far afield from where law is going. But the short answer is that the people of Guantanamo Bay, the Supreme Court held a decade ago, or actually 11 years ago, that the people in Guantanamo Bay have the right to petition for habeas corpus. That doesn't mean they get out. That means they can just talk to a federal judge. And these people have now been litigating in federal court for a decade, and almost, I don't know if any of them have been released by court order. The executive branch has found other countries to take a lot of these people, but some of them, they can't find anyone to take them, and they consider it too dangerous, so they will probably die there. They'll probably spend the rest of their lives. In fact, there was an article recently in the Times suggesting that Guantanamo is basically building senior facilities, right? Because these people now are getting in higher in age. Like they basically need like facilities for seniors. Right. But the important aspect of Guantanamo is because it was outside the United States, they would not be given the same procedures that a person in the U.S. would. Now, again, the people in California were in the United States. They were subject to our laws. We mentioned the travel ban earlier. The travel ban concerned people seeking entry, and they weren't in the United States yet. And those seeking entry basically get zero process at all. So it's a very different standard. Okay, anything else in the Japanese cases? Yeah, if you want to read the travel ban, I can give you an abridged copy. It's long, but it's an important case, but it's long, and I don't want to dwell any further on it. We have one more case to do today. Anything else?
Korematsu, for what it's worth, reminded me of the military. We still do business that way on a considerably smaller scale. If somebody misplaces a piece of government property, get a key to a barracks, do we stop and interview every single person till we find it? Nope. Everybody outside, nobody's moving until the property's found. We stay right here. It's like mass assimilation and control is the most efficient method. So in reading that, I could, still see some elements of how the government thinks at times.
Yeah, it's government control. Fortunately, the military control is usually reserved for those in the service, not domestic control. Okay. All right, let's do the next case. A little bit less depressing, maybe. I don't know. Iran, right? Dames and Moore versus Reagan. And by the way, it's not Reagan. It's not the President Ronald Reagan. It was the Secretary of the Treasury Reagan, R-E-G-A-N. Here he is, Don Reagan. Okay. I think, Lindsay, you're next.
Okay.
You want to give me the facts, please, in Dames and Moore?
So this was all during when Iran took hostages from the American embassy and detained them. There was a company, Dames and Moore, that was supposed to be conducting site studies at a proposed power plant in Iran. And they had not been paid, so they had filed suit against Iran, the Iranian banks, and Reagan.
Good.
Claiming that they were owed over $3 million.
Good.
And when the American hostages in Iran were released, the president issued executive orders nullifying all attachments and dismissing all litigation involving.
What does that mean, nullifying attachments? What does that mean?
So if there were attachments or judgments.
What was an attachment?
An attachment is like I'm not quite sure what an attachment is.
Yeah.
So a judgment is where you have to pay back.
Okay, very good. So let me explain this, right? In litigation, right, if I sued Lindsay, for example, and I get a favorable judgment, Lindsay owes me $1 million. She does not have the cash. What the court can actually do is seize property owned by Lindsay to put for sale by a sheriff. Right, that's called an attachment, right, where the government basically attaches or takes control of your property to satisfy a judgment. In this case, the problem was Dames and Moore had a favorable judgment, and they sought to attach property owned by the Iranian government to pay off that judgment. But as a consequence of resolving the Iran hostage crisis, the United States government and President Reagan signed an executive order. Actually, it would have been Carter, but then Reagan enforced it. And the executive order said we're going to nullify all of the attachments. And the reason why they did this was to basically start the clean slate, right? To improve U.S.-Iranian relations, we don't want to have these silly lawsuits dragging out in courts for years. We want to clean everything up. So what happens, you have this big pot of money, and we're putting it for claims. And people can then submit applications to take from this pot of money and resolve claims, not in federal court, but in the special claims process. And any existing judgments and attachments would just be wiped out, be nullified. Now, Dames and Moore, which is a military contractor, was not happy about this. And they actually sued Reagan, the Secretary of the Treasury, saying, hey, you violated the law, right? We have this valid judgment, we have this valid attachment, and your executive order, which you're enforcing, is violating our rights. So the case wasn't actually involving the Iranian government. The case involved a U.S. company who complained that the executive order was unconstitutional. Okay? So the question presented here was, did the president have the power to issue this executive order? This was not a statute, right? Congress did not ratify a treaty. Congress did not enact a statute. All we have here is an executive order. So Chelsea, if I'm asking you a question, the question is this: is an executive order lawful? What am I actually asking? What do I want you to tell me?
If the president has the power.
Very good. And where does the president get the power to issue an executive order?
The Constitution or Congress.
Perfect answer. That's Justice Black in Youngstown, right? That any exercise of power by the president must come from either A, the Constitution, or B, Congress, the statute. So Chelsea, finish it up. Is there any sort of executive power from the Constitution that gives the president this authority to suspend the judgments and the nullification of the attachments?
No.
No, there's not. So it's got to be from Congress. And this case actually gives rise to Justice Jackson. You'll notice that the majority opinion by Justice Rehnquist mentions Hugo Black for like one sentence and then talks about Jackson for a couple pages, right? Now here's a fun fact. Youngstown was decided in 1952. Who was clerking for Robert Jackson in 1952? William Rehnquist. Isn't that cool? But the funny part is that by the way, this is when Rehnquist was proposing to O'Connor, right? We proposed her by letter, by stationery from the Supreme Court, right? Remember this part? So while Rehnquist was busy trying to propose to Sandra O'Connor, he was also talking smack about his boss. He hated Jackson. He didn't like him, and he disagreed with him. And in fact, this is a fact that came back to haunt him later. He actually told Jackson that he should dissent in what became Brown v. Board. That Jackson, Rehnquist suggested that the court should not overrule Plessy. Now, Rehnquist later claimed that he was just writing a memo that the boss wanted. I'm skeptical. I think he was articulating his own views. But Rehnquist also said that Jackson's three-part test was stupid and they shouldn't adopt it. So Rehnquist was basically like the worst clerk in the world. He bombed out with O'Connor. He said dissent in Brown, and he said this Jackson-Youngstown thing is bad. All things which came the other way. Rehnquist perhaps didn't have the best clerkship, I suppose. But here's the fun part, right? Daines Moore was decided in 1981. There's William Rehnquist, and who was his law clerk? John Roberts. Yeah, there he is with that sphinx-like smile that torments me every June. By the way, I'll probably be very angry on Monday because there'll be an opinion from him coming up real soon. This Monday and next Monday, and a couple days after, we have probably 3 or 4 more opinion days. But at least this Monday and next Monday I'll be angry. Yeah.
So I was looking up Justice Jackson, and did he not have a really good working relationship with Justice Black?
Oh my God, they hated each other. The justices on the New Deal court, Black, Frankfurter, Douglas, Jackson, they hated each other so much. And as a result, they had these huge fights. There was a great book, if you wanted, it's called Four Scorpions. Like there were scorpions in a bottle, and they're all in the bottle together. They hated each other really bad. Yeah.
Is this why we see so many fragmented opinions in
Yes.
this time period?
Yes.
Okay.
Exactly. No, that's 100% correct, right?
Because I noticed that there's like
Every case,
so many
they'll write
concurrence,
separately.
So many dissents, everyone has to.
They
put
hated
their
each other.
dissents in.
Jackson wanted to be Chief Justice, and then Douglas wanted to run for president, and Hugo Black. I mean, these guys just they hated each other seriously. So one of the upshots of the present court is that justices actually get along. They're all friends. They don't agree on stuff. I mean, there was a piece in the Associated Press about a week ago. It was beautiful. Justice Ginsburg had cancer this year, and so she has trouble getting around, and she sits on the bench next to Clarence Thomas. And every day at the end of the session, Clarence Thomas gives her his hand and helps her off the bench, right? So in the opinions, they're throwing bombs at each other, right? But off the bench, he's helping her get off the bench, which I think it's a sweet moment. So they like each other. But back then, my God, Jackson, he hated Douglas, he hated Frankfurt, he hated Black, and they would fragment all these opinions. Also, Jackson took about 2 years off to go become the prosecutor at Nuremberg, and his colleagues resented him because they had a shorthanded court. They basically were at 8 justices for about a year and a half. And had all these opinions, which they couldn't get a judgment because they split 4-4. I wrote about this when Scalia died of having a 4-4 court for a while, so I used the Jackson time as a precedent. But it was a very contentious era.
It's just really fascinating to learn about all this, but also learn about the relationships between the justices going on in the background, because it really does explain why we get such fragmented opinions.
Oh, yeah. In fact, Chief Justice Warren, who was appointed in 1954, I think I'm right in their year, one of his greatest attributes was to settle the egos a little bit and get people to line up. And, in Brown, we'll read that in a couple weeks, he was able to get a 9-0 opinion, unanimous, not separate writings, not like 15 different opinions, this way and that way and that way. Frankfurter tried, but eventually he came along. There was one case we'll read also called Cooper against Aaron. This concerns desegregation in Little Rock High School, the Little Rock 9 you may have read about. And Justice Frankfurter wants to write a concurring opinion. And the chief was like, don't do this. We just want a unanimous opinion. So eventually, I think it was Harlan who said, Frankfurter, if you write a concurring opinion, I will dissent from your concurring opinion. And then so eventually Frankfurter said, fine. So what they did was they released the main opinion, and then like 2 weeks later, Frankfurter's opinion was released afterwards. Like it came out like 2 weeks later. So like he got it out, but like by that point, everyone forgot. Like the opinion came out, newspaper coverage. So they made persuade Frankfurt just sit on it for 2 weeks and release a little bit later. That's what they did. And then now no one reads it. I think I have like a paragraph about it in your book. That's Cooper against Aaron. You'll read that one about a week or so. Okay, but I want to walk through. So again, Rehnquist was actually the law clerk of Jackson. And then when Daines and Moore was written, you have John Roberts, who's the law clerk of Rehnquist. But as best as I can tell, Roberts had nothing to do with it. Rehnquist was a machine. He wrote this opinion by himself in about 8 days. he was I checked with Lyle Dennison, who was a reporter for 50 years of the court. He told me that Roberts was in a vacation home at this time and basically wrote the opinion basically like 1 or 2 sittings. So he wrote this by himself. Okay. And the important point about about Dames and Moore is that the court embraces Jackson, right? They basically say, oh yeah, Hugo Black, that's nice. Okay, let's talk about Jackson for a while. But I don't know that Rehnquist actually applies Jackson accurately, right? So I think, Tyler, you're next. Tyler, what are the 2 statutes that could potentially give the president the power to suspend the accounts?
International Emergency Economic Power.
IEPA, my favorite, maybe my 3rd favorite acronym, but it's called IEPA.
What's your first and second?
I think my first one is RLUIPA, the Religious Land Use and Institutionalized Persons Act. And IEPA, I think, is a close second.
All right. And then Hostage Act.
Now, okay. Does either IEPA, I love that one. Actually, by the way, President Trump considered using IEPA to impose tariffs on Mexico. That was actually the statute he was talking about. Yeah, right. Everything's new. Yeah. So Tyler, does either IEPA or the Hostage Act say anything about suspending accounts and nullifying attachments, etc.?
They don't directly.
Directly, but what do they instead suggest?
The congressional tenor.
Good.
Says that it would be in the spirit of the legislation for the president to do so, for the executive to do so.
Yeah, he writes. Excuse me. Both statutes are highly relevant in the looser sense of indicating congressional acceptance of a broad scope for executive action in circumstances such as those presented in this case. As a result, we are in the first Youngstown zone, right? Where it's, remember Jackson wrote express or implied authority? It's implied. Now, I don't think Jackson went quite that far. I mean, Jackson certainly said implied. But here, Justice Rehnquist reads the first tier so broadly that as long as there's some statute in the ballpark that concerns emergency powers, that's enough. And if that's the case, then Zone 1 basically swallows the entire pyramid, right? If we read delegation that broadly as Rehnquist does in Dames and Moore, then the president will always win. Because there are a lot of statutes. There are so many statutes in the books. And if you're a smart government lawyer, you can find some ballpark some statute that's in the ballpark that roughly corresponds with what the president's trying to do. Indeed, much of the current litigation concerning President Trump involves just that, where they find these statutes that are, close enough. And under, I think, the Dames and Moore statute, you have to be deferential. And this is, I think, a first-tier case in Youngstown. So again, I don't know if this faithfully applies Youngstown, but this is how Youngstown is now viewed by the court in Dames and Moore. And Faven, did Congress take any action after the president suspended all these accounts? Did Congress do anything in this case? They didn't disprove it, right? And in fact, some people said, yeah, we kind of like it, right? It's, good job, President. So from this, Rehnquist seems to suggest that Congress acquiesced. What's this word mean, acquiesced? It means give in, right? To acquiesce is basically like go along with it. So if the president did it, and Congress is going along with it, then it's not for the courts to second guess. It's one of deference.
It's the gloss.
Yes, exactly. That's my next point, right? That there are instances in the past where presidents have suspended accounts. And there's actually a gloss in the Constitution, which is Frankfurter's argument. Right? So in light of all of this, right, he says, the legislation character enacted, such as IEPA, and the history of acquiescence in executive claim settlement, we conclude that the president was authorized to suspend the claims pursuant to the executive order. And I think this is best used in a Youngstown Zone 1 case, maybe Zone 2. But the president had the authority to do this. Okay. Questions then on Dames and Moore v. Regan. Unanimous case. Rehnquist wrote it, I think, in 8 days. And John Roberts had nothing to do with it. Yeah, I've looked up Roberts' co-clerks. They didn't go on to things like him. I think they're lawyers, but they're not like Chief Justice. Everyone at Harvard thinks they're going to be the next Chief Justice, but they all can't be. You will be. Yeah.
With Roberts, was just a question about him. Did he seem like someone who was going to end up being on the Supreme Court or being Chief Justice?
Yeah, everyone thought he was perfect. But I think there's a problem when people think that they're perfect, that they're usually compensating for something. People who want that badly should never get it.
I mean, he seems very unassuming.
Oh, he's very charming. Yeah. I mean, the reason why George Bush picked him was they had a personal connection. When O'Connor announced her retirement, Bush had it narrowed down to, I think, 3 or 4 people. And Bush just didn't like the other ones. He just didn't get along with them. And Roberts he had a good chemistry with, and he thought he was good. And that was it, right? The decision of who gets picked is not always based on who the smartest man in the room is and who's the smartest candidate, who's the wisest candidate. There's a personality fit. I mean, even President Trump met with all the top nominees, and he liked Gorsuch, and he liked Kavanaugh the best, and that's what he picked. And that's one of the president's prerogatives. Now, sometimes their judgment's not the best, but they get that power. All right, questions on Dames and Moore? All right. For class for tomorrow, we are doing the appointment and removal power. That is, when can the president make appointments to executive branch agencies, and what limits can there be on the ability of the president to fire people? And that's the reading for tomorrow. I have a flight tomorrow. I'm supposed to be landing at Hobby at 4:20. So I should be here on time. If I'm late, I'll let you know, but I should be here on time.
Oh, Hobby.
Yeah.
Hobby's not too bad.
At that hour, it's about 30 minutes. I should be here on 5. But I have a thing in Austin tomorrow on something, so I'm just flying in the morning, coming back. I'll be here tomorrow. I'll be there for like 4 or 5 hours. That's normal. Normal for me. All right, anything else? All right, I'll see you all tomorrow. Thank you so much.